like that. Like I said, I was in a bad predicament, and I was using that to like pay.
What is this charge? Manufacturer delivery, Sam?
Let's break this down. It's not being charged with real drugs. This is simulated controlled substances, so that means fake drugs passed off as the real thing, legally still a felony in Texas. Why? Because it's all about intent to deceive, and prosecutors hate deception.
Which allegedly
All right. It's very weird. All right. Can you call IT to come up, please? All right, so where are we on discovery? I know he has a new case as well.
He does, Judge. So the criminal episode here picked up by the feds. Under indictment with them. He has a setting in late January.
Oh, once the feds enter the chat, everything changes. Federal charges usually carry heavier penalties, tighter procedures, and less wiggle room. This local case suddenly riding shotgun to a much bigger ride.
I understand it. I've been conferring with Mr. Garahan, and while we've not any concrete disposition, I think there's a strong likelihood that whatever happens there will substantially affect the cases here. My understanding it's the first setting. I know the docket says 2, but I don't ever recall having been.
Oh, I have it as the first setting.
Oh, you do? I was lied to.
And not by Jason Garahan. Those are fighting words. Because this is how I know it's the first setting here. I have nothing written on here.
I don't know if you can push this beyond.
This is classic jurisdiction. Juggling the local court is stepping back to let the feds move first, which often means the outcome that will shape any plea here. It's like legal dominoes, one move topples the rest.
7, because that's his next federal court setting. The more information I learn about what their intentions are, I think the better off we will be to figure out what we are going to do. So that is my request if the court could grant it.
All right. So this can come back. Do you have any objection to his request?
No.
How long do you expect the trial for that entire class?
I thought
Yeah. Well, we're doing.
I think it's 2 weeks in Santa Monica.
All right, because we're doing jury selection for that on February 7th, but we have motions on February 3rd. I can set it for your client for the week of February 3rd, since it's just. Is everyone okay with that?
That should be fine. I mean, first day
There's nothing earth shattering that's going to get, but just more information.
All right, so February 3rd is a Monday. We do the 3rd, the 4th, or the 6th.
Just make sure I'm not going to be out of county, Judge. The 4th is a good day for me.
All right, we'll recall this on February 4th, and you say that the feds have already picked up the case?
Yes, ma'am.
All right, 2025. Thank you for addressing the public report. Once you sign the reset form, you're excused. Norman Cuellar is being recalled for February 4th. That'll be for discovery.
Sir.
Court is calling 2024 CR 2669, State of Texas versus Omar Flores. Can I have parties announced for the record? For the state? Defense.
Scott Hill for Mr. Flores.
Are you Mr. Flores? All right, did you review the document entitled Motion to Enter Adjudicate? Excuse me. Mr. Robinson, don't talk about how the court reported. You just asked the deputies they're looking to that man. Oh, no problem. All right, we're back on the record. Mr. Flores, did you review the document entitled Motion to Enter Adjudication of Guilt to Revoke Community Supervision with your attorney? Speak up. Did you understand? Are you saying Omar Flores, who was placed on deferred adjudication in 2024 CR 2669 for the offense of possession of controlled substance, penalty group 1, less than 1 gram on June 13, 2024 for a period of 3 years? Is that you? All right, stay.
On or about the 5th day of August 2024 in Bexar County, Texas, the defendant Omar H. Flores did then and there fail to complete the substance abuse treatment facility with BCC SCD in and that the defendant refused to sign amended conditions to attend as directed by the supervision officer and or the court in violation of condition number 39.
How do you plead to that? True or not true? Did you understand by pleading true to violation of condition number 39, the court will find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine? On that, do you still wish to plead true to violation?
When you plead true to a violation, you're basically saying, yes, judge, I messed up, no trial, no excuses, just straight to sentencing. And in this case, the judge isn't sold on giving him a soft landing.
Number 39. Court will find violation of condition number 39 true. Is there a proposed agreement?
Yes, Your Honor. Supervision, assessment, 1244A at 200 days confinement in the county jail.
Would you fall into that proposed agreement? Why do you not fall?
Let me give you a little context on why. First, he got denied felony drug judge. Whatever reason, I don't know why he didn't qualify for it. He's got 5 children under 8, and his wife was late in the pregnancy. He's been in custody since May 20th, Judge. So he was in custody when he entered his initial plea. Once he realized he was going to have to wait for a bed, and being saddened, he didn't want to be, always thinking he didn't want to be away from his family that long and potentially miss.
Wait, you're saying he's been in custody since May?
Yes, Judge. He's been in nonstop custody since before he took the plea. I believe it was June.
Alright, so we're not going to count. Alright, how long is he? So he's been in custody since June.
He was in custody before he took the plea.
I'm not even going to consider he's been in custody before he took the plea. Alright, so he's been in custody since June. When I ordered felony drug court, and he didn't qualify for felony drug court.
Correct, Judge.
All right, probation. Why is it that he didn't qualify for felony drug court? All right, felony drug court was at capacity, and he said he didn't have a drug problem. And part of the reason why you were in custody, you say since May, is because April you had a court date and you did not show, so you were a BF was issued, so you were remanded without bond. So that's on you. You didn't appear, and felony drug court didn't accept you because you said you didn't have a problem, and they were at capacity. All right, so may continue.
Judge, the way he's thinking is, I just got to get home to my family as soon as I can. So we're talking around the jail and funeral. He's going to be waiting months for a bed. So for whatever reason, he didn't want to do that. He wasn't going to be able to visit his family when he was in custody.
Here's where emotion meets the law. He stayed in jail not because he wanted to, but because he thought it was his only way to see his kids. It's raw, it's heartbreaking, but will that outweigh the court's frustration? That's the million-dollar question.
And that was very important because he can have visits at the Berry County Jail. So that's why he didn't go, Judge. Obviously, he probably regrets that now, and the situation is, but we're hoping the court will consider the fact that he's been in jail in custody for so long that that's enough punishment for him.
I'm not going to sentence him under 1244. And with regards to his children, I realize he has children. That's why I ordered parenting classes. And I don't know how he expects to help his children or be present in his children's life when he has a drug problem.
Well, Judge, the whole time he's been in here, he's realized the effect he's had. He's never been away from his family. He misses his son. He hadn't even had a chance to build his son, and that's killed him. Where he's a family man, he loves his kids. He sees what this has done to his children. He's told me I'm never touching anything again. I don't want to put them through this. So I believe him. Now if the court's willing to entertain releasing him back on deferred and maybe give him some outpatient treatment.
Now, what's his criminal history?
As far as I can tell, Your Honor, he doesn't have any.
All right. Did you run NCIC?
Not today, Your Honor.
All right. Do you have a DCIC, NCIC. Doesn't matter if it was run today. He's been in custody for a while. Do you have that?
Do not, Your Honor.
All right, so the state, you need to get that. Then the court will make a decision. All right, thank you. Gonzalo Garcia.
Are they cleared up?
Well, that is good, but this is now. He's working on that. So on this list, where are we on discovery?
We're good on discovery. Actual secret state, they are operating
All right, Norma, I need a 30-day reset on Garcia Gonzalo. All right, so we'll come back on January 9th, and then I'll expect an update on PTE. All right. Thank you for addressing appropriately for court. All right. So where are we on discovery? I see we have one case that's indicted and several that are not.
That's the problem. We can't go forward until like those United States. They need a lab report, a couple of drugs.
So when are you all expecting lab reports?
Judge, we're reaching out to the lab today. It's with the RS finding that on one of the cases, the audio specifically reach out to the complainant, and so planning on doing that today. As far as I know, the lab is back on, if we have a mind that we can ask them to expedite it and give status update from court.
All right, Norma, if you recall, this was January 30th. It's Jerry McGee. So we'll bring you back on January 30th. If they have something sooner, they'll let your attorney know and you can come back sooner. Any other questions?
No, that's it, Judge.
All right, thank you.
I need a reset forward.
No. Court is calling 2020 CR 7207, State of Texas versus Keandra Marshawn Davis. Can I have parties announced for the record for the state? Defense. Counsel, you're on this side. And are you Mr. Davis?
Yes.
All right, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it? Are you the same Keandra Marshawn Davis who was placed on community supervision in 2020 CR 7207 for the offense of assault, family, choking, strangulation on August 3rd, 2021 for 4 years and extended for a total of 2 years? Is that you? State?
Yes, Your Honor, we do have an agreement.
What are we proceeding?
We are going to proceed on both violations of condition number 1.
We'll read it into the record, please.
Yes, violation of condition number 1, on or about the 30th day of June 2024 in Tarrant County, Texas. The defendant, Keandra Marshawn Davis, committed the offense of driving while intoxicated in violation of condition number 1.
Will you plead to that true or not true?
True, Your Honor.
Violation of condition number 1, on or about the 30th day of June 2024 in Tarrant County, Texas. The defendant, Keandra Marshawn Davis, committed the offense of possession of a controlled substance, PG1, in violation of condition number 1.
Will you plead to that true or not true?
True, Your Honor.
And the state will waive the remaining violations, Your Honor.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of conditions 1 and 1, the court can find it true, grant the motion, and sentence you up to 4 years in prison and up to a $1,500 fine? Knowing that, do you still wish to plead true to violation of conditions 1 and 1? Court will find violation of conditions 1 and 1 true. Is there a proposed agreement?
Yes, Your Honor.
And what is that proposed agreement?
That proposed agreement is to grant the state's motion to revoke community supervision, revoke the community supervision, and sentence the defendant to 3 years in the Texas Department of Corrections.
Is that your agreement?
That is, Your Honor.
Are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, the court will follow your agreement, sentence you to 3 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Pantandra, P-A-T-A-N-D-R-A, Booker, B-O-O-K-E-R. Is there anything else from either side with regards to sentencing?
Not from the state, Judge.
Judge, I believe Mr. Davis has some.
Yes.
So we have a child together, and the first time I was sitting on document,
placed on probation. It was to be no contact with Dr. Booker. Then you had a motion to revoke file, and then that was for a violation of condition number 5. I denied the motion, alternating conditions, transfer to Dallas, weekly reporting, do a hotline, and then August, this was set for August 24th for a contested hearing in person, and then on August 24th, there was a violation of condition number 15. That judge found it true, and then today, this is where we are. I've never ordered a no harm for injurious contract. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Change your life. You say you have a child, you want to be in your child's life. Think that you want your child to be proud of you. Part of that is stop drug use. Alcohol is drug. You can't control the use of it. Be kind to your child's mother, but you have not been. When you bring assault choking, that means you choked her. I mean, that's no excuse. You can't say, oh, I shot somebody, but we're back together. That was 4 years ago. Do not minimize what you have done. All right, good luck to you.
Thank you, Judge.
You're welcome.